Okay. Next is that if you could now talk about the mediation agreement, since while describing initially, you said that mediation will be as which comes out from the agreement. So if you could talk about what are the what is mediation agreement, and can it be like a clause, or does it have to be a specific agreement, and something anything that you'd like to share around that?
Yeah. So for as far as mediation agreement is concerned, that agreement can be a separate agreement to a commercial transaction also. Parties entering into a commercial transaction can then have a separate agreement to specify all the details of the mediation. As we have seen as a practice, uh, most of the commercial agreements already have a dispute resolution mechanism in it. And out of those, most have the arbitration yet, because this is a new concept. So arbitration was always there. In case of any disputes that arises between the parties will first try to, in the similar language, the parties will first try to settle the disputes amicably through negotiations and etc. And if they are unable to do so, then they can approach they can approach the method of the arbitration. But as far as the mediation now is concerned, so mediation agreement or mediation clause in a specific agreement will mean the same thing. Like the arbitration agreement and the arbitration clause in a particular agreement means the same thing. This will also mean the same. This will also mean the same thing.
Right.
It will have to be. It will have to be mutually agreed between parties. Where the mediation will happen, what rules will, whether it will be an institutional one or an ad hoc one. So that will be decided, and everything will be noted down. So this is what will will form part of the mediation agreement or the mediation clause in a particular agreement.
So what you're saying is that either means it can be a mediation agreement, just like an arbitration agreement. It can be a mediation agreement. And
Yes.
Did you say that can it be a clause also other than the agreement?
Yes, a mediation clause, definitely. Like you add an arbitration clause for dispute resolution in a commercial transaction or any kind of a commercial transaction. So we will see draftings of mediation agreements, mediation clauses also now in the same agreements.
Okay, and so do parties have to mention the name of the mediator in the agreement itself or the clause itself?
Well, that's not necessary, because as we have, I will draw my attention. I will draw my explanation and conclusion from what we have seen in arbitration. It is not necessarily required to specify the name at the time of execution of the agreement. The parties can simply decide that where in case of any dispute, one party will maybe may assign a name, and the other party can agree or not agree. Again, we go back to the same thing. If the parties don't agree, then the mechanism of whether approaching to the Mediation Council of India or specifying the name of the mediation service provider, so that we still have to see. But yes, it's not necessary that they have to specify the name of the mediator in the mediation agreement or the mediation clause.
Yeah, but what is interesting to note, Varun, is that in case of a ad hoc arbitration, if the parties are not able to zero in on a single name, then they have to approach the high courts to get an arbitrator appointed, which may appoint from an arbitration institution, from a panel of judges or otherwise. But in case of mediation, I think everything, all the shots will be called by the Mediation Council of India, right? If it is not named, then Mediation Council of India may sort of appoint an arbitrator like that, right?
Apart from yes, I agree with this. And more than that, in order to add, there is also the appointment of the appointment of a mediator is specifically also mentioned in the Act. It comes from Section 8 of the Act, which is there. So who can be appointed as a mediator? So it has to be a person of any nationality can be a mediator. It's not necessarily required to be an Indian person from Indian nationality. Or the parties can freely decide who can be a mediator if a mutual name is consented by both the parties. And if parties don't reach to an agreement, then yes, the party seeking for mediation shall file an application with the mediation service provider or the Mediation Council of India.
Yeah, or else talking about institutional mediations in future. And if we, for example, are able to see some good mediation service providers being body corporates who have registered themselves as such as an MSP with the Mediation Council of India, then I think just like we put institutional arbitration clauses in agreements, like these disputes will be subject to DIAC or SIAC or LCIA, like in international arbitrations, or like Delhi or Mumbai Center of International Arbitration, etc. Similarly, I think we might be able to, or parties might be able to include certain MSP names if they become really do good service, and if they become good names in mediations. They may
Yes,
be able
yes.
to put those names in the agreement, that in case of a dispute will be referred to this mediation center, and then that mediation center rules and bylaws will take over and appoint the mediators, right?
Correct. Yes.
Right. Understand. Good. Okay, and since we're talking of agreement, mediation clause or mediation agreement, can there be oral mediation agreement, Varun?
No, it has to be a written agreement. It has to be an agreement signed by both the parties and mutually agreed. So agreement in itself has to be written. Obviously, there are oral agreements, but if you orally decide on someone, then you can very easily agree it was never decided. So it's, yes, as per the act, it's required to be written, a written signed agreement.
Right. And if suppose there is no mediation clause in an agreement, or there's no mediation agreement per se, and the dispute occurs, and at that juncture the parties intend to refer themselves to mediation, can it be done?
Yes, it can be done at that point of time also. Unlike arbitration, again, arbitration has to be pre-decided. Like as you asked, arbitration has to be pre-decided for the commercial for any dispute or commercial transaction. For mediation now, it's no more necessary. Parties who have not previously agreed for going for the mediation under this act, in case a dispute arises, the parties can still approach, one party can initiate and give its consent or give its intimation that they want to initiate a dispute resolution mechanism under this act. And if the other party agrees, then yes, both the parties can file for with the service providers or the council of the mediation council for the appointment, or appoint any single one also.
Yeah, unlike arbitration, where the existence of a clause or an agreement prior to the dispute is essential for parties to refer to arbitration. Here, even if there was no clause or no agreement, however, even after the dispute has occurred, and if both the parties consent, I think the key word here is both the parties consenting to subject themselves to mediation, they can refer the matter to mediation, right?
Correct.
And that's, I think, one of the key differences. So since we are okay, one more thing on the agreement itself. So I think in this online era where everything is happening online, can the if the consent of the parties subsequent, suppose there was no agreement, no clause of mediation, can the parties consent on email exchanges or emails that okay, we would want to subject to mediation? Will that be construed as a mediation agreement?
Yes. I should have mentioned it earlier also when I was explaining it. Now, electronic communications will also be treated as mediation agreements or acceptance of going for mediation. Exchange of emails will very well be included in the same. Right. Yes. So even if
please proceed.
Even if the parties have not decided priorly that they will resort to mediation under the Mediation Act, then yes, if the dispute arises in future or at any point of time, then yes, on email also, if it is decided, then yes, it is a mediation agreement.
Right. So that's quite a welcome step, because everything is going online, and this is quite less in procedure, I would say, to that extent, quite relaxed in procedure.
Yes.
And therefore enabling or facilitating mediations. Yeah.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.